Good evening, everyone. Thank you very much for joining us at this seminar. I've got some standard jazz to say before we begin, and hopefully we can kind of get straight into it. So everyone has been placed on mute. Please post any questions that you have in the question and answer window, and the chat function is enabled for other comments, queries or feedback. Please don't put any questions in the chat function. All the resources, any of the slides that you see today will be circulated if you've registered as a delegate after the webinar. This webinar is also being recorded, and what that means is the audio and video of the panelists and anyone who speaks, if they're unmuted, will be recorded. This webinar also might be shared on our marketing channels and included on our website and social media, so you might see yourself on YouTube. Please refer to the instructions which are now in the chat window if you're experiencing any technical difficulties. So the seminar this evening, we've got a great lineup for you. And so the pandemic has exacerbated the difficulties faced by individuals who are ineligible for public funds by virtue of their immigration status. Access to appropriate support and accommodation has become even harder. We know that the central government response has, in some cases, weakened provision for vulnerable migrants and is subject to a number of ongoing challenges. Local government support has been variable and somewhat inconsistent. To help us kind of make our way through it this evening, we'll be hearing from Taimur Lay and Raza Halim on asylum support when it comes to challenging subsistence rates and the Home Office's new regime. We'll also be hearing from Connor Johnston with regards to local authority powers to support rough sleepers during the pandemic. And finally from Miranda Butler, who will be dealing with trafficking support in sudden cessation and inadequate reinstatement. Thank you very much. I'll ask then the first speakers to start. Thank you.
Good evening. I think Raza and I are going to map out, I suppose, the shifts in Home Office policy, specifically since March this year in asylum support, because that's affecting provision on the ground. It's leading to a lot of problems for destitute asylum seekers, and it's necessarily affected the ways in which our cases are being brought and judicial review challenges are being pursued. And a number of existing problems in asylum support have been exacerbated by those shifts in policy since March because of the public health emergency. But in turn, the Home Office has then, since March, sought to respond from their, in their view, to the greater volume coming through the system. Their response to it has led to further problems in turn, which has led to further challenges. And so we thought it would be useful if Raza and I map out what's going on in asylum support from that perspective first, and it will logically lead on, I think, to consideration of other knock-on effects for local authorities and for, in particular, victims of trafficking who find themselves increasingly languishing in, for example, hotel support for much longer than they are supposed to be. I'll just bring up the slides. So we'll all be familiar with the cohorts, if you like, that we're discussing here. Section 95, asylum seekers, destitute, recognized as such, and therefore eligible for support. Section 4, failed asylum seekers who for various reasons cannot reasonably be expected to leave the jurisdiction and are also destitute and in need of support. And then finally, those eligible for Schedule 10 accommodation, think of it as a residual category. Those, for example, who have not claimed asylum, have never claimed asylum, might have an Article 8 claim or be an EEA national with something in the system. And the phases I'm referring to here are the first phase from March, where there was, frankly, kind of chaos. in terms of people making applications as destitute and those applications not being dealt with within appropriate timescales, or there being grants of support and then an absence of provision. And so, generally speaking, judges were quite open to granting interim relief on an urgent basis to make sure that people weren't street homeless and telling the Home Office to get their act together. But that phase one eventually evolved into this phase two, I think roughly since the summer, where some of the urgent actions taken by the Home Office in response to COVID created a new normal. And part of that new normal we're living with now, and it may be that we're living with it certainly next year and longer. Part of that new normal is the normalization of hotel accommodation for long periods rather than self-contained dispersal accommodation. And also quite sharp and, until now, unreasoned variations in subsistence support in cash for those people in hotels. And then you see I've talked about a September 2020 review, which Raza is going to touch on also, leading to a new decision at the end of October. Some of you might have seen the letter to stakeholders saying we've reviewed things and we've decided that people in hotels should get £8 a week, subject to other reductions, and that still hasn't been brought into place or implemented. So that's the terrain we're going to go through this evening. Now, when COVID hits, there are already real problems in the mechanisms of asylum support, which makes that system even more stretched and dysfunctional. So we were already well familiar with prolonged stays in initial accommodation. That's been happening for years. And inadequacy of that dispersal accommodation. There had long been challenges to subsistence rates, although, as we'll discuss, there had been a cluster of litigation on the overall rate. At the moment, £39.63 a week for those in self-contained accommodation, and why that wasn't enough. Inadequacy of accommodation for all of this cohort in terms of being vulnerable asylum seekers, but especially others with additional needs. And finally, even before COVID hit, there's always been provision within the asylum support system that even if your essential living needs are being met, but you have additional needs, there's meant to be clear, reliable ways in which you can ask the Secretary of State for those needs to be met. So if you're an asylum seeker in Section 95 accommodation, you can apply for additional needs under Section 96. And if you're in Section 4, it's under Regulation 9 of the 2005 regulations. But these were already routinely either not dealt with or ignored or very hard to challenge. So that's the problem before COVID hits. And the reason I'm emphasizing this is that the Home Office narrative since March has been, we're doing our best in exceptionally difficult circumstances. We've raised the subsistence rate, by £1. I think it's less than £1. We've raised the subsistence rate. We're actively expanding provision. We're having to use hotels because especially in high COVID areas, we can't get our private providers in to sort out self-contained flats. So that's their narrative. The problem with that narrative is that this isn't new. So 2007, the House of Commons Home Affairs Select Committee was warning initial accommodation is unsuitable for long-term use, not provided for that purpose. People in hotels have little choice over food, receive no financial support, and can have difficulties accessing third sector and advocacy networks. So once we got to the summer, we again had the Home Affairs Select Committee pointing out that a system that was spectacularly unprepared for a crisis had been hit by that crisis. And then the National Audit Office also reviewed things and was noting that it was all, or a lot of it was about a backlog going back to the end of 2019. these problems being pre-existing problems, I've found do play on judges' minds. So the Secretary of State position opposing interim relief is often, well, stick with us, we're doing our best. But where judges see that actually this was a longer term systemic problem, shouting COVID in the courtroom becomes less compelling as an argument. Raza, did you want to say something about some of these existing problems? Because I think in terms of our casework, I think we're used to certain kinds of challenges pre-COVID in terms of how the system dysfunctioned. I know you early on did a lot of interim relief applications to get people off the streets, essentially, and how those have changed a little bit as we got into the summer.
Yeah, I mean, there were a whole multiplicity of examples of applications to the High Court for urgent interim relief, and they would be either failures to accommodate, failures to transfer to self-contained accommodation, pregnant mothers, single mothers, cases where an agreement had been reached not to evict someone because it was accepted that they were victims of torture and shouldn't share, and then subsequently being sent eviction notices, infestation cases, cases where you're forced to live with someone who your criminal bail says you're not supposed to be, within, well, certainly not a shouting distance. Or people who've been moved away from access to HIV treatment. So it shows itself in any multiplicity of human experiences. But our experience has been, my experience certainly was, that we succeeded in every single application we ever lodged, and that doesn't speak to the advocacy, but really speaks to one, the abject failure of the Home Office. And also the boldness of solicitors who, as Taimur identifies in what he calls phase one, there was a lot of scaremongering going on the part of the Home Office, partly flowing from an early case called detention action, where relief was rightly sought for a significant class of detainees, but very, very early on at the beginning of the pandemic, and it was said that the Secretary of State should be given huge amounts of latitude in the pre-action period. And the answer to that is not to be cowed by the requirement to do so, but really just to make sure that you, in every single case, properly use the pre-action period, even if it's in a short period of time, to put the Secretary of State on notice. And the court, in every single case where it sees a genuine emergency, has responded. But it does require some sort of responsible pre-action work being done in order to get there. And then I think over time, as we've moved into the summer and now, the Secretary of State's attempt to use that card has sort of diminished in weight and value, and the court no longer takes that kind of attempt to keep cases away from underneath their nose very seriously, particularly in cases which engage Article 3 obligations and so on. So I think that the Secretary of State has lost its kind of honeymoon period, and we're now seeing that the court is willing more and more to grant relief in individual cases. And also we saw recently in a case we'll come to in a moment called MK, general relief, albeit in mealy-mouthed terms. But I won't go any further than that now because we'll take things out of order.
And at the start, I mentioned that there were Home Office policy responses that have in fact generated more problems and more cases. I think responses is too generous, because response suggests some kind of planning, whereas I've called them shifts here because it's been very ad hoc and it's been very unclear. So we've lined up some of those key shifts and how they're affecting things now. So critically, of course, there was a decision on the 27th of March 2020 to suspend cessations of support due to impact of COVID. So that meant that even if you no longer qualified under Section 95 or Section 4 or whatever it was, you wouldn't be kicked out of where you were. So the Home Office main line is to say, well, the flow in the system stopped. Normally people are constantly moving out of that accommodation and then new entrants are coming in. So that leads to them having a problem over provision. So then they say, well, we are expanding provision via our private providers, Serco, ClearSprings, all the rest of it. And they are saying to people who are stuck in hotels, so it's still, Serco's the provider and They're the person in reception at the hotel to whom you might complain about things. But they're saying to our clients, you might want to get dispersed to self-contained accommodation, but there is a general cessation of dispersal because of COVID. And that's presented to people and to the lawyers as policy. And it was only through disclosure and then later through a imaginatively edited letter to Ubah that it transpired that there were temporary casework measures approved by Public Health England in April, providing for the exceptional dispersal of vulnerable groups. So interestingly, it wasn't just medically vulnerable groups. You're more likely to get a serious case of COVID, therefore you shouldn't be in a hotel because there's more people and you can't self-isolate. You should be somewhere where you could self-isolate, let's say self-contained accommodation. It wasn't just that. It was also any other group who shouldn't be in that kind of accommodation long-term. Families with children, victims of trafficking. But it took months to get any clarity through pre-action requests, Part 18 requests for information, direct judicial questions, to get a clear sense of what these temporary casework measures were and how they're meant to be applied. And I still have cases where they claim to have considered someone under the temporary casework measures, but have no written record of it. So those temporary casework measures were an emergency policy brought in that doesn't seem to have been rationally or consistently applied. Other shifts, there's a review of subsistence rates, 8th of June 2020. So that's when the minister says there's an immediate and exceptional increase from 37.75 to 39.60 for those in self-contained accommodation. And that's for both Section 95 and Section 4. So Section 4, you're meant to get less money. Traditional rationale is that you're going to be in Section 4 for a lesser amount of time, and there are certain needs that don't apply to you. But for both groups, up to 39.60. So this was sold in political terms as a generous move by the Home Office because of the exceptional circumstances we found ourselves in. But what's missing from that increase is the reality, my number 5 here, that for the vast majority of people stuck in the hotels and the hostels, because you're in full board accommodation and you're provided with food and drink and supposedly provided with some of your essential living needs, additional cash payments ranged from nothing every week to £5 to sometimes £10 without any seeming individual assessment or rationale. And we'll come on to some of the challenges that led to, including MK, as Raza has mentioned. And then finally, we had, much more recently, the use of barracks as accommodation in Folkestone and Penally in Wales, which itself was wrapped up with a kind of public fever over the numbers of new arrivals in boats. And this seemed to be a decision that was taken in political terms as the Home Office having to resort to extreme measures because of external forces they couldn't control. And then those reviews of subsistence rates develop slowly over time. I've put review in inverted commas here because in August 2020, they were saying in response to pre-action letters and grounds for judicial review that don't worry about people getting £0 a week in the hotel who can't buy non-prescription medication and can't get the bus and can't buy additional food for their kids. Don't worry about that because we're reviewing it. They were saying that in August. But there certainly was a review in September 2020 well, I think Raza can speak to this because I think this September 2020 review happened in direct consequence of the MK litigation. But it was presented at one stage as it was a review of all kinds of subsistence rates, whether you're in self-contained or dispersal accommodation. And it culminated in any event in that 27th of October letter. But Raza, in fact, this might be the right time to talk about MK.
Sure. Well,
because that September 2020 review they didn't admit that it was because it was being litigated, did they?
No, I mean, in classic form, it suggested this is all happening organically and through the benevolence of the Secretary of State's consideration of the need the destitute who were seeking a safe place to live. But it was absolutely in direct response to our case. One, because it was so obviously clear that they'd done absolutely nothing to assess individuals. Going back to your point earlier about the disparate amounts of cash provided to those in hotel accommodation or other shared accommodation run by Serco and G4S, those amounts were just sort of doled out by the individual private contractors, certainly with no assessment that we could see on any of the cases that we that we saw. And so it often meant that there was always a massive shortfall. And the point that we're making in our case is that the Secretary of State has undertaken a very careful analysis of the needs a careful analysis of what the cost of quote unquote essential living needs are. And the phrase essential living needs comes from the High Court judgment of Mr. Justice Popplewell in Refugee Action. And that is all derived from the reception directives, which the Secretary of State is obviously bound by. And by reference to that amount, the amount that the Secretary of State herself has assessed, it's clear that and the Secretary of State is entitled by reference to Regulation 10 to offset the full cash amount by services provided in kind. So if you were entitled to Section 95 support and you're being housed in a hotel who is providing you with quote unquote full board, so food, clothing, laundry, etc., then they can offset the full cash amount by the services they're providing. But what we often saw was that they weren't being provided with, for example, the very basics in terms of toiletries, nothing for travel, nothing for communication, etc. And because of the arbitrary way in which those things were provided to asylum seekers, they decided to undertake this review and then reach this decision, which is in Taymor's slide, which was sent to chief executives of all NGOs dealing with asylum, those dealing with asylum seekers who need support, saying that we've now undertaken our review and we've reached a decision to increase the amount, to provide everyone with £8 per week going forward, and back payments of £3 for a period ending in July, and then a period of £4.70 up until the 18th of October. Now, all of that is sort of, in many ways, sort of mind-numbingly boring to listen to, but it is important, obviously, for our clients because for several reasons. One, the back payments that they're promising, they haven't yet worked out a mechanism to provide these back payments. So our clients and those people who continue to be in need continue to go without and fall further and further into sort of desperation as they found ways to either borrow money or go without for the entire period up until now. Secondly, the back payments that have been made, and this is the amended case that we're making in MK, don't in any event cover things like other essential living needs such as travel, because they say, well, travel wasn't really allowed until July, when that's wrong, because we know, all of us personally and otherwise as a matter of law, that people were allowed to travel for essential reasons such as finding food to eat and medicines and so on. And there's no rationale that's been provided for why the prospective payments of £8 a week doesn't cover communications. They say these hotels provide Wi-Fi and so on, but as we know, many asylum seekers don't come with smartphones. And even if they do, they can't use the Wi-Fi to make calls to their support workers or to their solicitors or to friends and family, all of which has been accepted in Refugee Action, which gives effect to the Reception Directive as being essential living needs. And so the Secretary of State, although trying to make our case academic by undertaking what they say is this entirely independent review and decision, have still got a way to go. And that's why our case is outstanding. But yeah, so I mean, that's what we face in the new year. But in the meantime, as I say, people who need money, they have various mechanisms, as Taymor has mentioned, to ask for it individually. And so those who are listening to this seminar may well be advised to make those applications, either just simply putting forward the case under essential living needs or on a discretionary basis under Section 96. Though I would say, if your expenses come within the framework identified in Refugee Action, then absolutely you shouldn't be having to use Section 96 to obtain money which you are entitled to as a matter of statute. And the Secretary of State has not until now reached a proper lawful decision, we say, either on the money or on by undertaking a tame site inquiry as to need. So very, very important in the meantime to get what your clients need. And I think Tamer's experience and others on this call may well have found in their own experience that with a lot of pushing, you get somewhere, albeit, subverting people like Migrant Help, who have been, I'm sorry to say, less than helpful.
Yeah, and the fact that the new £8 policy has not yet been implemented means that judges are granting interim relief of the Home Office having to pay £8 a week. And all you need to say is, well, they've said that their review says it needs to be £8 a week. My applicant, my claimant gets 0 or 5. Order £8. Now, I suspect that there's an issue about the broader implementation of the £8 a week because they need sign off from the Treasury. I don't know what the reason is that it's taken them since the 27th of October. They just haven't implemented it. But this is something that, as Radha said, this is something that's going to continue into the new year, as well as potentially challenges to the levels of discretionary back payments. They're calling them discretionary back payments very carefully. They're not saying, we recognize now that we made a mistake and you in fact did have a right to subsistence for clothing in April 2020. They're just saying, we've decided to make a discretionary payment to you and we make no concession at all.
As I say, I wouldn't accept that as being sufficient to discharge the Secretary of State's statutory obligation to meet your client's needs. And certainly, just because they've offered you £3, that should be the baseline, and you're certainly entitled to more. I'm aware of time. I'm only just going to make a couple of points while I'm on the microphone, which is to say that in respect of Penally, which Tamer mentioned earlier. These are attempts at sort of vast attempts at resolving this ongoing accommodation issue, which, going back to our first point, the court has had less and less sympathy with, and the conditions are getting worse and worse. Connor and I are working on a challenge to the accommodation of asylum seekers in the barracks for a whole host of reasons. I mean, the whole thing is so misconceived that we've been unable to restrict ourselves to making anything less than 8 different arguments. I'm not going to recite all of them now, but suffice it to say that for the purpose of this seminar, there is exactly the same problem infecting the accommodation of asylum seekers in that camp as there are in general hotels and other things, except their situation is made even worse because of their remoteness. And so it means that even if they had money to travel, they've got to encounter, well, first of all, the expense of traveling, as well as the racism outside the camp and so on. So that's happening there. It's also happening in Folkestone. And the same goes for cessation, which we have temporary relief on because of there was a judgment from Mr. Justice Ford in a case called QBB, but the Secretary of State has now accepted that she's not going to be evicting anyone until she formulates a new policy. And we don't know when that will be. But we're braced and preparing ourselves. Again, it's a case that Connor and I are working on for what that next decision will be. So
yes,
and
that shows that there's been a combination really of individual challenges with strong facts getting relief, but also systems challenges, wider challenges. So including MK and the Penally challenge. And relatedly, the success in the High Court in the challenge to the provision of Schedule 10 accommodation, which wasn't just related to failures to provide for those who were in detention, but also for those who were street homeless and not getting Schedule 10 accommodation. So I think we could probably finish there in terms of where we're heading in terms of a variety of challenges, and the Home Office position and policy position remains unclear. And that poses real challenges to claimants because we are seeking to attack a moving target often. And that's been the experience, particularly since the summer.
Taimur and Raza, thank you very much. Really interesting. I'd just like to remind all of our participants that if you have any questions, please do put them in the Q&A and we will have plenty of time at the end to answer. And now moving on to our next speaker, it's the fabulous Connor Johnston, and he will be discussing local authority powers to support rough sleepers during the pandemic. Thank you, Connor.
Thank you, Ubah, and thanks Taimur and Raza. Yeah, so what I'd like to speak to you about during this segment is local authority powers to pick up rough sleepers, and it's something I feel like I've been thinking about quite a lot, and I suspect many of you have, since March of this year, because it was in the early days of the pandemic, the central government response to the impact of COVID was to write to local authorities on the 26th of March, telling them that it is our joint responsibility to safeguard as many homeless people as we can from COVID-19. Our strategy must be to bring in those on the streets to protect their health and stop wider transmission. This approach aims to reduce the impact of COVID-19 on people facing homelessness and ultimately on preventing deaths during this public health emergency. It is now imperative that rough sleepers and other vulnerable homeless are supported into appropriate accommodation by the end of the week. So what that letter denoted was the start of what we've, I think, in the sector have come to describe as the Everyone In initiative. It was exhorting local authorities to do exactly that, to bring everyone in. There was no qualification within that letter based on immigration status. It was simply recognizing the risk of death posed by COVID-19, saying that all rough sleepers should be brought in. And local authorities, almost without exception in the early days, acted with great expediency and I would say humanity. Dame Louise Casey, about a month after the minister's first letter, wrote to local authorities noting that more than 5,400 rough sleepers had been brought in. So that was over 90% of those on the streets. And to me, that is just an indication that rough sleeping generally, can be ended if we put our collective minds and will to it. And within those cohort of rough sleepers, the Housing Communities and Local Government Select Committee noted the following week there were a significant number who had no recourse to public funds. So the evidence of the London Borough of Greenwich to the Select Committee was that 900 of the 3,600 within London had no recourse to public funds. But one of the points that the committee noted, and it was something we'd, as in Garden Court, had flagged in our response to the Select Committee, was that there is, although councils had been doing as asked, there was a lack of clarity as to what powers they were acting under. What powers do they have to support those with no recourse to public funds? And so the committee flagged that in its report, and the government response was that local authority powers are clear. And they wrote to local authorities in those terms the following month. Luke Hall's second letter, I want to take this opportunity to restate the government's position on eligibility related to immigration status, including those with no recourse. The law regarding that status remains in place. Local authorities must use their judgment. So to my way of thinking, this response is anything but clear. From the point of view of local authorities trying to work out, can I help this person? From the point of view of a homeless person who's sleeping outside Victoria Station, who is trying to work out, do I have a right? Do I have an opportunity to be supported by local authority? This response is completely opaque. It's simply saying the law hasn't changed, use your judgment. So that's the sort of context in which this question about the extent of local authority powers arises. And following on from that second letter of Luke Hall, my personal experience has been there's been a lot more divergence in local authority practice on accommodating those with no recourse. Some are doing it, some are not doing it, some are saying we can't do it. So what I'm interested in is what is the correct approach? What powers do local authorities have? And in looking at that, what I'm focusing on is statutory powers. So local authorities, perhaps this is an obvious thing to say, they're creatures of statute. They can only do that which statute permits them to do. So the Everyone In guidance, and I call it guidance using it loosely, it's not statutory guidance as far as I can see. It's not a policy or anything like that. It is simply a letter. It might direct the use of local authority powers. It might influence the use of the powers in the sense that it's something that has to be taken into account, but it can't create powers unless there is already a statutory power in place. So what is the source of that power? Now, I'm hoping that that question is going to be addressed in the case of Ubah and Brighton and Hove, which is going to be heard next week, which is going to be dealing with some of these issues in the context of a failed asylum seeker who was turned away by Brighton and Hove Council in early September. I say I hope these questions will be answered. These cases always turn on their facts, and I think that there is always a chance, particularly with a case like this, because it concerned a failed asylum seeker who was eligible for Section 4 support, that the court might just consider whether the local authority were correct on the facts of this case to turn this person away, and not grapple with the much wider issues about what local authority powers exist. So that's really what I want to consider now. And what I should say by way of health warning is that pretty much everything I say from this point in is open for debate. There aren't clear answers to these questions. If there were, we wouldn't be having this divergence in approach. We wouldn't need this seminar. So you may not necessarily agree with my analysis of the legal powers, but I hope whether you agree or disagree, what I will do is flag the sort of issues you should be thinking about when considering whether or not a power exists. So a couple of preliminary points before I look at the powers in any detail. The first is just a reminder that support may be necessary. Support may have to be provided by local authorities to avoid a breach of the European Convention on Human Rights. Now, there are two ways that can be relevant to the powers I'm going to be discussing. The first is the powers, so the imperatives under the Human Rights Act under sections 3 and 6 to interpret legislation compatibly with the ECHR and for public bodies to act in compliance with the ECHR. But also we have the restrictions on Schedule 3 in Schedule 3 of the 2002 Act, which we need to keep in mind, which apply to a variety of people, including those who are in the country unlawfully, and exclude them from support, save to the extent necessary to avoid a breach of ECHR. So that applies to some, but not all of the forms of support I'm going to be looking at, so particularly the Care Act and Localism Act. Now, exceptions to Schedule 3, as I've said, they arise where it's necessary to avoid a breach of EU law or ECHR rights. And typically, when we're looking at rough sleepers, what we're concerned with is Article 3. You'll all be familiar with the Limbuella threshold, the idea that if somebody is deprived of alternative sources of support, is unable to support him or herself, is by the deliberate action of the state denied shelter, food, or the most necessities of life, then we're in Article 3 territory. Then we're in the territory where a local authority may be obliged to provide support. But of course, Limbuella was in the context of asylum seekers, people who could not return to their country of origin to seek support. So if we're going to be engaging Article 3 outside of the context of asylum seekers, we need to do more than show that the person is street homeless. We also need to show that they are going to be facing a practical or legal impediment to return. That means it's not reasonable for them to avoid their destitution by going back to their country of origin. Now, in the current circumstances, that is a very, very practical issue. What it probably means, if you're going to be looking at whether or not there is a practical or legal barrier to return, is looking at local lockdown restrictions, looking at the relevant regulations that restrict freedom of association, freedom of movement, and trying to figure out the extent to which they would practically prevent somebody from returning to their country of origin. The view taken by the Asylum Support Tribunal, which I think is probably the experts tribunal in these matters in relation to when support is necessary to avoid a breach of the ACHR. What the tribunal decided, the principal judge, in a decision prior to the recent lockdown, was that support should generally be provided to avoid a breach of Article 8 in old style Tier 3 areas. So we've had a subsequent lockdown and we're into new style tiers. The tiers, we're told by the government, are tougher than the ones before. So based on the approach of the Asylum Support Tribunal, I'd be saying that there is at the very least a good argument that anybody who is in new Tier 3 and potentially Tier 2 as well, the restrictions are such that they're not going to be able necessarily to return home to seek support. Allied to that, there are very practical issues like, are flights actually running to the country of origin? Is the country of origin accepting returns? Many countries during the pandemic have simply not been allowing commercial flights to land and not been allowing people in. So that's the kind of thing we need to be thinking about. Other articles that may be relevant during the pandemic, well, Articles 2 and 8, I would say. I mean, it's not hyperbole to say that there is a real risk of death during the pandemic. Early on, in the early months of the pandemic, the Lancet article written in the Lancet estimated that the action taken in pursuit to everyone in saved at least 266 deaths. So we are certainly in Article 2 territory, I think, when we're dealing with those who are particularly vulnerable. For those who are perhaps not facing that level of risk and perhaps not facing the destitution threshold in Limbuela, we still could be in Article 8 territory. I mean, I think that Article 8 is wide enough to encompass those who are seriously ill. So those are the articles that we need to be thinking about. Then just a final contextual point before I turn to the specific powers is to think about who it is we're actually talking about. Who is it who is potentially going to be looking to local authorities for support at the moment? And primarily it's going to be anybody who's ineligible for mainstream homelessness support, anybody who's not eligible for assistance under Part 7 of the Housing Act. So that encompasses a fairly broad cross-section of people. We've labelled this seminar as barriers to support for those with no recourse, and it's perhaps convenient at this point to say what I mean by no recourse in this situation. I'm talking about people who are here with leave to remain who have a no recourse condition attached to their leave, but I'm also talking about those who, as a legal consequence of their immigration status, do not satisfy the relevant eligibility criteria. So failed asylum seekers, for example, illegal entrants and overstayers, they are not going to be eligible for support under Part 7. So functionally, they have no recourse to public funds. And we're also thinking about certain EEA nationals. Now, they may have no recourse for a variety of reasons. It may be because they're here lawfully, they're exercising treaty rights, but their treaty rights don't allow them to qualify for support. So, for example, job seekers, those exercising their initial right to reside, but also EEA nationals who are not exercising treaty rights. So all of these cohorts exist within the homeless population. All of these people who are maybe sleeping rough and maybe potentially be looking to local authorities for support. Now, some of these, but not all, may be eligible for support from the Home Office. So I say not all, like in particular, those who are here lawfully but have a no recourse condition. They're not asylum seekers. They're not failed asylum seekers. They're not liable to removal, so they're not eligible for Schedule 10 support because they can't get immigration bail. That cohort is not going to have anywhere they can go but their local authority. The same would apply to EEA nationals who are exercising treaty rights that don't give rise to eligibility. So those people, local authorities are their only safety net. Others, like failed asylum seekers, they might well notionally be eligible for Home Office support. But as we all know, in practical terms, that can take months. People can be on the street for huge lengths of time before, well, potentially before they even realise they are eligible for Home Office support. And then they can be homeless for a period of months while the Home Office considers their application. So I think in those cases, local authorities may need to step in. Now, a local authority, I think, would be entitled to say in those cases that if the person is eligible for Home Office support, then they should seek that support. And they might well be entitled to attach conditions to any support which they do provide, which require the person to take action fairly speedily to access Home Office support. But what I don't think a local authority can do is stand idly by while somebody is facing a breach of Article 3 and allow their homelessness to continue on the basis that the Home Office may, at some undefined point in the future, potentially support them if an application is made. I don't think that is a human rights compatible solution. So I think in those cases, local authorities would need to step in, and potentially then judicial review proceedings would need to be issued against the Home Office. But I think there is potentially a gap there for local authorities. And I don't think that is a new proposition. It's effectively the same proposition that applies in relation to Section 17 support. The Divisional Court in VC in Newcastle said that if a local authority is to avoid providing support under Section 17 to a failed asylum-seeking family. I mean, firstly, those cases will be rare because generally Section 4 support won't be enough to meet their needs. But in any event, it needs to be sure that the support is actually going to be provided. And I think there is an analogy here between Section 17 and Section 6 of the Human Rights Act. There's a positive duty to protect, and that duty is not going to be discharged unless the local authority can actually say with a degree of confidence the Home Office is going to provide the support that is needed. So all of that is by way of context. Turning to the powers themselves that may be available, I want to start on those powers that I think are of particular relevance during the pandemic, during this time when public health is at risk. And Section 138 of the Local Government Act, I think, is a good starting point, because that really is the sort of the parent legislation that governs local authority powers. So under that, under that provision, excuse me, I've just lost control of my slides for a moment. Under that provision, local authorities can, in cases where there is an emergency or disaster involving destruction of danger to life, and where they're of the opinion that it's likely to affect the whole or part of their area or all or some of its inhabitants, they are allowed to incur such expenditure as they consider necessary in taking action themselves, calculated to avert, alleviate, or eradicate the effects of the disaster. So it's a very broadly framed power. And when we look back at the minister's letter to local authorities, 26th of March, I think it seems fair to say that this power is opposite. The minister was describing this as an emergency. He was exhorting local authorities to take everyone in order to protect the danger to life, in order to alleviate the risk of death. So it seems to be the kind of situation where the broad powers under Section 138 would be available. I've referred to no case law in relation to the use of Section 138. And the reason for that is because there isn't very much. There is a few cases that refer to this provision obliquely, but there is nothing that says that this is a power that can or cannot be used in the way I'm suggesting. But certainly, I would say that the language is broad enough to do exactly what it is that we are proposing. I describe it as a general power, and one that may be relevant to strategic and policy decisions. And the reason I've done that is because I think there are two types of decision that we need to be thinking about in these cases. We want to be thinking about the individual decision. Do I provide support to this particular person? But we may also need to be thinking about the policy decision that the local authority has made about accommodating or assisting those with no recourse generally. Because as in the Brighton case, which is to be heard next week, what has happened is there has been a council level decision taken relatively recently that they have no power to assist. So Section 138 is not just relevant to the question, do I help this individual person, but it's also relevant to that strategic policy decision. Do I have any power to affect this, to help this group as a whole? And I think we may need to be considering in our cases both types of decision. And the important thing about Section 138 is it's not subject to immigration-based restrictions. So whether or not somebody is here lawfully, whether or not they are exercising treaty rights is neither here nor there. This power exists. Allied to that, we've got Section 2B of the National Health Services Act 2006 Act, which allows local authorities to take such steps as are considered appropriate for improving the health of the people in its area. And that may include providing assistance, which can be financial assistance, to help individuals to minimize any risks to health arising from their accommodation or environment. So again, like Section 138, this is not subject to immigration-based restrictions. It's something that I would say is at the very least is relevant to the policy level decision, can we help this cohort? I suspect that local authorities are not going to be, they're going to be reluctant to use this sort of power because there is likely to be a mindset that this crosses over onto the turf of the local health board. Typically, if people are so ill that they need support under the from the NHS, then they are going to qualify for continuing healthcare, and they are going to be supported by under local health by the local health board. They're not going to be supported by local authorities normally. So I think there might be some reluctance to use this power, but purely as a matter of statutory construction, I can't see any reason of principle why it couldn't be used. And there is no case law to suggest that it can't. Then finally, in particular relevance during the pandemic, we've got the power under Section 19(1) of the Care Act. So under Section 18 of the Care Act, there's a duty to help those who have eligible care and support needs. But if an assessment has been done and it has been found that somebody does not qualify for that duty, for example, because they only meet one of the eligibility criterion, then the power under Section 19 arises, and that power is going to become a duty where support is necessary to avoid a breach of the ECHR. And that was commented on by Mike Fordham sitting as a deputy High Court judge in the case of Ubah. Now, often with this particular client group, with no recourse clients, the problem you have in the context of Care Act support from social services is that that support is not available where somebody's needs arise solely from destitution. But of course, during the pandemic, many of those who need support, their needs are not going to arise solely from destitution. They are going to arise from a combination of destitution and the health risks posed by COVID. So that may mean that the Section 19 power is available. And that is subject to Schedule 3 of the 2002 Act. So there are immigration-based restrictions there, unlike Sections 2B and Section 138. But in human rights cases, then they will be dispensed with. So those are the powers I think are particularly relevant now while we're dealing with COVID. But I think many of these questions are going to remain relevant after the pandemic has eased. Yeah, I think local authorities may well be asking themselves the question after the pandemic has subsisted. You know, what powers do we have to help those with no recourse? Partly because we're heading into the winter months and local authorities year in, year out, have been looking to accommodate rough sleepers under sort of emergency winter protocols, but partly also as a result of our exit from the European Union and the eligibility changes that are going to happen on the 31st of December. I think there is going to be rather more cause for local authorities to consider assisting those with no recourse. So what powers are going to be relevant once the pandemic eases? The first is one which I think is often overlooked, which is under Section 180 of the Housing Act, is the power to give assistance by way of grant or loan to voluntary organisations concerned with homelessness. I say it's often overlooked because I think that we all think of assistance under Part 7 of the Housing Act as being subject to eligibility criteria, and actually that's not the case with Section 180. There is the power to give grants or loans, which is available to in any circumstances. It's not subject to Section 185. And so what local authorities are doing there, if they are helping rough sleepers, is not helping them directly, but giving third sector, for example, assistance so that they can do it themselves. So again, this is going to be something that is particularly relevant to local authorities when they're formulating policies on helping rough sleepers. And so if you are looking strategically about a local authority policy, this, whether or not local authorities considered using this, is going to be something that you need to think about. And then finally, we have the general power under Section 1 of the Localism Act. And I think for those of us who have been thinking over the last few months about local authority powers, this has probably been the one that we've been scratching our heads over the most. So the power under Section 1 is the power to do anything that individuals generally may do. And it is subject to immigration-based restrictions. It's subject to those under Schedule 3, directly, which say you can't provide localism support to those who are excluded under Schedule 3, but it's also subject to indirect immigration-based restrictions, which are contained in Section 2. So Section 2 of the Localism Act contains what are referred to as pre and post commencement limitations on the exercise of their power. And what they mean is that under Section 1, a local authority cannot do anything which it's unable to do by virtue of a prohibition, restriction, or other limitation expressly imposed by a statutory provision. Now, the post-commencement limitations, so limitations that have come into force after the Localism Act, if they're going to apply, they have to refer to the localism power expressly. But that's not true for pre-commencement limitations. The limitation doesn't have to say that it applies to the Localism Act power. Now, in the case of AR in 2018, it was held by the High Court that Section 185 of the Housing Act, which governs eligibility for homeless assistance, that is a pre-commencement limitation on the provision of accommodation under the Localism Act. Now, that case disapproved the earlier High Court authority of GS and Camden, but the reasoning in it has subsequently been approved by Mike Fordham in the case of Ubah. So what that is saying is that if you're not eligible for support under Part 7, then you can't get Localism Act support. You can't circumvent the Housing Act by trying to get in through the Localism Act. And the reasoning of the judge in that case, it followed on from the Court of Appeal decision in relation to the predecessor powers under Section 2 of the Local Government Act in the case of Cairn and Oxfordshire. And Cairn wasn't about Section 185, but it set down what I think are the general parameters of what a pre-commencement limitation is. So 2 main points to emerge from Cairn. The first is that there is a difference between a limit on the scope of a power and restriction on the use of a power. So putting it in very simple terms, there is a difference, or this is the way I interpret it, there is a difference between a statute saying that you cannot do something and a statute which does not say that you can do something. The latter is just a limit on the scope of the power, and that's not a pre-commencement limitation. But where a statute says that you can't do something, that is a restriction on the use of the power. That is a pre-commencement limitation. So that's the first point from Cairn. The second point from Cairn is that, as I've already mentioned, a pre-commencement limitation doesn't need to refer specifically to the general power. So in relation to the Localism Act, it doesn't need to mention the Localism Act. So Cairn was concerned with Section 21 of the 1948 National Assistance Act. The restrictions under Section 21 didn't mention the Local Government Act, but that didn't matter. The fact that the restrictions in that case says you cannot provide support to people whose needs arise solely from destitution, that was enough for it to constitute a pre-commencement limitation. Because the point of these limitations is that the Localism Act and the Local Government Act before it weren't intended to override legislative schemes that already existed. They're not meant to be used as tools to get round restrictions in other legislation. So the judge in AR was just applying those principles. Is AR correctly decided is the question I've posed at the top of this slide, because I think the fact that it departed from a previous High Court authority definitely caused some concern in the sector. My view is it is insofar as it relates to the facts of that case. There was some Court of Appeal authority which suggested that Section 185 might not be a pre-commencement limitation, but it was very much over to comments, and I see AR as applying very directly the principles from Cairn. I think it's quite difficult to argue with. Can you avoid the effect of AR by providing funds for accommodation rather than accommodation itself? So that had been an option that had been canvassed in a much earlier case of J. Gunay and Citizen. I think probably not is the answer to that. For that argument to work, you would have to say that paying for accommodation rather than providing it itself is not something that can be done under Part 7 of the Housing Act. And I don't think that's right. And I don't think that has ever been right. Local authorities routinely provide homelessness assistance by the way of paying for deposits, for example, or paying for first month's rent. And I wouldn't like to argue that that is not something they can do under Part 7. So if they can do that under Part 7, then that is excluded by Section 185. So I don't think you can get round AR like that. But I think AR does need to be restricted to its facts, which is that was a case where the claimant was not facing a human rights breach. It was a Lithuanian national who, on this facts, could return to Lithuania to avoid destitution. So I think that is the limit of the principle of in AR, is that Section 185 does prevent Localism Act support being provided to somebody who's not eligible for homeless assistance, but only if they're not facing a breach of the ECHR. If they are facing a breach of the ECHR, then we have to read down Section 2 of the Localism Act to disapply the limitations, because otherwise we're left in a situation where the legislative scheme as a whole is not human rights compliant. So I think that is the route. If none of the other powers, which I've referred to already, are available to help a person, and the person is facing a breach of their human rights, then it is the Localism Act power, which I would say is the final safety net. So just to round up then, before I pass over to Miranda, central guidance, government guidance on provision of accommodation to NRPF rough sleepers has been woefully inadequate. It's been far less clear than it should have done, being given the importance of this question. There have been a great many local authorities that have assisted a great many people who have no recourse during the course of the pandemic. And I find it very difficult to accept the proposition that they have no power to do so, and the implication that in helping these people out of humanity, that they have been acting unlawfully. I think there are a number of powers which either directly or indirectly can be used to help this cohort. Section 138 Local Government Act is a way they can do so directly. Section 180 of the Housing Act is a way to do so indirectly. And those powers are relevant to both strategic decision making, formulating policies, but also relevant in individual case. In respect of individual cases, support under the Care Act and Localism Act, I think, is also going to need to be considered, particularly where support is needed to avoid a breach of the ECHR. That's going to be individualised human rights assessments, and those assessments are going to need to consider, if appropriate, things like practicalities of return to country of origin and whether and when Home Office support may be available. So I'm going to conclude what I have to say there, and with apologies to my co-speakers for overrunning, and hand over to Miranda now.
No need at all for apologies. That was very interesting and educational for me, at least. Now, I'm going to be talking about the support available to victims of trafficking, and I'm particularly going to be talking about the changes that have been taking place over the last few months. I'm going to start off by walking us through what some attendees may be very familiar with, which is the legal framework providing for support for victims of trafficking, before coming on to the practicalities of what's been happening lately and what we can do in response to it. So what is, to my mind, the primary and most useful basis for support being given to victims of trafficking is in Article 12 of ECAT, which mandates that parties have to adopt legislative or other measures necessary to assist victims in their physical, psychological, and social recovery. Whilst I haven't given you the entirety of Article 12.1, that does at least include subsistence support, appropriate accommodation, psychological and material assistance, and access to emergency medical treatment. Article 12 is also clear that in providing that support, the state has to take due account of the victim's safety and protection needs. And this is going to be a recurring theme. And in fact, if there's one takeaway that you have from this talk, it's going to be that. It's going to be the fact that support for victims of trafficking has to be person-centred and focused on that individual's recovery. And unfortunately, the framework that we have for support all too often fails to meet that goal. The ECAT explanatory report builds on what Article 12 says and very clearly points out that this assistance and support duty in Article 12 is for the purpose of addressing the trauma that victims will often have as a result of their trafficking, and should allow victims to recover and escape from the influence of their traffickers. So it plays a protective role as well as a rehabilitative one. And once again, the explanatory report to ECAT is crystal clear that the state has to take due account of individual needs when providing support. There is similar language in Article 11 of the EU Anti-Trafficking Directive, but to my mind, it's largely coextensive with what we already have in ECAT and doesn't have the helpful language of the explanatory report. So that's why I tend to start there. What the government has done is we've passed the Modern Slavery Act, and that provides at Section 49 an obligation on the Secretary of State to issue guidance about, inter alia, the support that victims should get. Those of you who've read the case of K&AM that I'm going to come on to will note that whilst the Modern Slavery Act was passed in 2015, the Secretary of State was caught out several years later, having failed to issue any guidance whatsoever under that provision until Mostyn pointed it out to them in court. So that's the domestic framework that we have for guidance on supporting victims. And as so often with cases involving victims of trafficking, the successive governments have failed to consider whether we need a robust legislative framework to provide for support and assistance. and have allowed the international framework to largely be sorted out in court, and even that happens all too rarely. So I've just mentioned KNAM. This is really the principal case that we have on the support duty under ECAT in particular. It is really worth reading in full and is quite helpful for anybody who is seeking to obtain enhanced support for clients who are potential or recognised victims of trafficking. I've picked out 3 key points here. But what Mr. Justice Marston said in this case is, firstly, that your entitlement to trafficking support is not means tested. So even if you have an individual who's receiving support from a friend, or in his words, a kindly relative, you should still be entitled to this. Secondly, the reference in Article 12 of ECAT subsistence is not talking about what Tamar and Raza have been talking about, simply meeting essential living needs, a bare level of staving off destitution. It's more expansive than that. And so he goes on to refer to what might reasonably be required by a victim of trafficking in order to both escape their traffickers and recover from their experiences. And he makes specific references to support providing for smartphones, travel, recreational items, and entertainment. And of the many people here who've represented victims of trafficking, I'm sure that very few of you will be able to give me examples of your clients being able to afford smartphones, travel, recreational items, and entertainment on the trafficking support that they receive. So what does that framework, both in the case law and in the relevant legislation, add up to? That means that victims should be getting needs-based support, as we know that encompasses financial support, accommodation, and the health of the support worker. But very importantly, that should be to meet that individual's needs, both in order to recover from their experiences of trafficking and to protect them from re-trafficking. And that has to go further than merely providing you with your essential living needs. The details of that support are set out in the Modern Slavery Act guidance, which has changed since I first drafted these slides, which is perhaps indicative of how changeable Secretary of State's position can be on guidance and support for victims of trafficking. How long does the support last? It should last from a positive reasonable grounds decision to at least 45 days after a positive CG decision. If you want to see if you want to look at the judicial consideration of the point at which support should end, you want to start by reading NNLP and the consent order and statement of reasons that case resulted in which the Secretary of State accepted that arising principally out of ECAT and that needs-based approach, it wasn't lawful simply to have a cut-off for all victims of trafficking 45 days after a positive conclusive grounds decision, leaving people often in destitution, but rather there needed to be a needs-based assessment of what that person required on an ongoing basis. There is now a policy further to that, the recovery needs assessment policy, and your clients should be having needs assessments both on referral into the NRM and approximately 45 days after they receive a positive conclusive grounds decision. I'm sure we're all aware of the extremely long delays within the NRM, and that means that often our clients are on this support for extremely long periods, which makes it all the more important that we are able to advocate for them to get the most useful and substantial level of support possible in order to allow them to recover and to protect them from re-trafficking. Unfortunately, the Secretary of State has not always had those goals at the forefront of her mind, as we saw this summer. So suddenly this summer, I'm sure some of you started getting desperate calls from clients, and I certainly started getting some desperate calls from some of my wonderful instruction solicitors saying, my client's a victim of trafficking who's been receiving support. She's waiting on a conclusive grounds decision, and her support's just been stopped. Her support worker was told a few days ago that it was just going to stop suddenly, and now she's receiving nothing. And what it turns out happened was that the Secretary of State decided to suspend, or effectively cease, trafficking support to victims of trafficking in initial accommodation. So in the accommodation that Tamer and Raza have been talking to us about, where very often individuals are getting any asylum support. And this was directly in contradiction of the Secretary of State's own policy, the statutory guidance that I've already referred to on the support that victims should be getting. And whilst I've been involved in litigation around this issue, I have never seen a reasoned explanation as to why this happened. The closest I've got is this response, which came out in one of my cases, in which the Secretary of State accepted that there was an obligation to support, but explained that there had been a review about the level of support that would be given to potential victims of trafficking in initial accommodation. No apology, no meaningful explanation as to why that meant everybody's support being unilaterally stopped. However, fortunately, that support now has been reinstated. Whilst I'm referring here to the latest version of the statutory guidance, the clarification of the guidance came in August, and I'm going to refer firstly to the general provisions for victims of trafficking who aren't also asylum seeking, but the changes in question do relate to victims of trafficking who are also asylum seekers. So as many of you will be aware, the framework for support for victims of trafficking is very roughly that if you are in self-catered accommodation, you get £65 a week. And if you're in catered accommodation, you get only 35, with slightly different sums available for dependents and for people who are, say, living with friends in what's called outreach support. It's worth noticing at this point that these sums are largely the sums that have always been in place since financial support was introduced for victims of trafficking. And that by itself raises questions that I'll come on to address in due course. So what's the position for asylum seeking victims of trafficking, including those in initial accommodation since the cessation of support over the summer? The position of the Secretary of State is, well, we'll give you your £65, but the way that we're going to work that out is that we are going to give you your asylum support, and then we're going to top you up with £25.40 by way of support as a victim of trafficking. And the Secretary of State's position is, that's absolutely fine, you're getting your £65. But of course, all of you having just listened to Tamer and Raza's talk, you'll be very well aware that in practice, that may mean that a victim of trafficking who was previously getting £65 a week is now receiving £25.40 and nothing more, because asylum support has been so drastically cut and watered down for individuals, particularly in initial accommodation. And Samantha Knights and I are currently involved in a challenge I've referred to there, to both that level of support that's being provided to asylum seeking victims of trafficking, merely giving them £25.40, which seems to be light years away from what KNAM refers to, and also the basis of the calculation. Raza's already referred to the refugee action case, which has led to a detailed assessment of the actual essential living needs of asylum seekers. To my knowledge, no similar calculation has ever been undertaken for victims of trafficking, nor are the sums they receive uprated for inflation, leaving them with a real terms cut every year. So I imagine a lot of you here will be aware of the problems in practice that all of these issues lead to. Firstly, I'm highly concerned that the history, first with trying to reduce trafficking support rates to match those of asylum support, which led to KNAM, and the cessation of support in July 2020, those raise serious concerns about whether the Secretary of State is willing and able to comply with her duties under ECAT and elsewhere. There's then a question as to whether the subsistence that our clients are receiving is in fact adequate. especially where it's not being uprated for inflation, there's no meaningful assessment. There are also questions in practice about whether the needs assessments that are being undertaken are actually identifying what needs individuals may have over and above the £35 or £65 that they're likely to get whilst they're in the NRM. And of course, there's the broader problem that victims of trafficking lack, in most cases, a right to work or leave to remain. And I was instructed in the case of EOG, which some of you may have seen was handed down last week, where again, Mr. Justice Mostyn talks in quite powerful terms about the impact of the hostile environment on victims of trafficking and their recovery. So my last points are going to be a couple of proposed potential solutions. Firstly, when we have clients who are having their needs assessed, we can really assist by proactively identifying and evidencing their needs and explaining why those needs go beyond the support and accommodation that the statutory guidance provides for. This is perhaps linked to my point 3 there, which is making one-off requests through support workers for larger items of expenditure, and articulate, firstly, reminding both support workers and, if necessary, and the Secretary of State of the needs for the obligation for support to be individualised, and making sure that when we're making these requests, doing it in a way that is individualised and linked to recovery and protection from re-trafficking. Finally, litigation has been very useful. This is not an area where I anticipate there's going to be meaningful legislative change, and any policy change is unlikely to be helpful. So challenges to substandard accommodation support in individual cases and strategic litigation do have scope for success. Thank you. That's everything I wanted to cover. So I'll stop sharing my slides and see if we've got any questions.
Thank you very much for that, Miranda. Very comprehensive. So we've got one question, and I think maybe this is for you, but could be answered by anyone really. And the first question is, do you have any concerns, or rather any reassuring responses from the Home Office about workload and decision making given the influx of cases and reallocation of staff that's happening and will continue to have next year, especially those who are still living in poor conditions whilst awaiting outcomes?
Well, I'll take that, if I may, as you've indicated, it might be one for me. I'm not sure I have much by way of support or encouragement to offer. Again, if I can refer to the case of EOG from last week, that is a case that is highly critical of the severe delays in decision making within the NRM. I appreciate that's not specifically to do with asylum support or dispersal, but it is linked to it, and it is representative of a broader problem of widespread delay. And in that case, Mr. Justice Mostyn talks at length about the assurances that were given only just about a year ago by the Secretary of State in a case called O, saying everything was going to get better and the delays were going to stop, or at least improve, and the fact that unfortunately they've only got worse. But I wonder if Raza and Taimur may have more insight into delays in asylum support.
I mean, certainly there are huge delays for the reasons that Taimur outlined, euphemistically in this dehumanizing term called outflow. Not enough people leaving accommodation or the country so as to create space within the accommodation estate. Also, because decision making was put on pause, you had lots of people who had claims outstanding and remain outstanding for some time. All of that notwithstanding, as I say, when you make the individual claim, the Secretary of State, on every occasion that we've issued cases, and I've issued too many to recall, has miraculously found accommodation. First of all, accommodation where they said they had none, or accommodation of the kind that we say we need. Now, it shouldn't require litigation in order to obtain that kind of outcome. It is uncomfortable to think that this person got what they got because they had access to a lawyer and they had the nous to access one or was referred to one. And you think of all the others who didn't have that privilege or that benefit through good fortune or otherwise. But we know there's ample public law authority for the fact that the Secretary of State can't rely on resources in order to discharge her obligations either under the Human Rights Act or her statutory obligations is no good answer. And to some extent, she was seeking to rely on a resource argument, or not. In fact, she wasn't to some extent. She was expressly relying on a resource argument right at the beginning of the pandemic in terms of in terms of her own staff, and she was also relying upon the demands on the accommodation estate. But that didn't, one, stop claims being issued, orders being made, and the Secretary of State providing the relief that we sought once we got the orders that we sought. So, apart from it being as a point of principle, not an acceptable answer to a need rooted in individuals' psychological circumstances or whatever, or just the conditions in which they're living in, it's just no good answer practically either. So I don't think that should prevent anyone from bringing a claim, because frankly speaking, if pushed, an answer is found.
I think that the shortage of dispersal accommodation is also linked to the inaction or ineffective action of private providers to whom it has been, that role has been subcontracted. And when you see chains of emails between the Home Office and private providers, where the Home Office will just send the same email every week saying, can you find a flat? Can you find a flat? Can you find a flat? No, no, no. You know, when the judges see that chain of correspondence, it does not constitute, sort of expeditious or reasonable efforts to obtain something. And as Raza says, it's remarkable how quickly things are found once an order is made. Although it is true that the resource problem does play into timescales. So, the degree to which a judge will say you've got to do this within 24 hours as opposed to 72 or a week or 2 weeks. So taking a practical stance yourself when you're seeking relief on timescales at least can be a way to signal to the judge that you're the reasonable party. But yeah, it's when you're seeking, for example, self-contained accommodation in Bristol, specifically, it's got to be in Bristol. That's where they, for whatever reason, and even the Home Office have accepted it's got to be in Bristol. Bristol goes into tier 3. That does it has an impact, and it has and the arguments from the Home Office will have a resonance. But I had a question, in fact, for Miranda about those trafficking victims with reasonable grounds decisions in the hotels for long periods. And it seems to me that there's a system issue in the initial needs assessments being made by referrers, because the default position is that if you are just merely, without more, a victim of trafficking with a reasonable grounds decision with an asylum claim, you're going to go into a hotel under Section 95. That's the default position, explicitly. Unless the initial needs assessment done by the Sally Army or whoever says that you've got additional needs, which means you should be in a self-contained accommodation or in a particular place. But I rarely see an initial needs assessment that is, well, it's hard to see them because it's difficult to get them disclosed and the Salvation Army don't hand them over. But I think that's leading to a lot of victims of trafficking with reasonable grounds decisions in hotels, but it's not always. It's a tricky job to get them out into self-contained, having regard to both the resource issue and the initial needs assessment upon which the Home Office will rely when they say that the hotel is adequate.
I couldn't agree more. I think everything you've said there is bang on. And I think this was the point I was attempting to get at in my presentation, that in my experience, needs assessments basically proceed on the basis that what you're going to get given to you by the Home Office is going to be enough, unless you can show something truly exceptional, without recognising that being a victim of trafficking is itself exceptional and makes you and gives you distinct needs from the broader asylum-seeking population, which are themselves highly vulnerable. So I think that's, again, something that we should really try and push back against. And I think you're right that there is a systemic problem there. The systemic problem that we're challenging in PM and LT is to do with the level of financial support. But I think there is an accommodation issue as well, especially when it comes to risk of re-trafficking for a lot of these people.
Thank you, Miranda. So there is another question and a comment maybe for Connor to take. And the comment is, local authorities who want to provide accommodation and support are also concerned about how to fund that. Assuming that they have the powers and maybe the duties, is there anything to be done to put pressure on central government to fund any legal remedies or pressure?
That's a really difficult one. So that's a question from Sue Lukes. And Sue, I think I would struggle to think of anything that you yourself won't already have thought of. I mean, there are things I can say in response to that. The Select Committee on Communities, Housing and Local Government, I referred to their interim report earlier. They are producing a further report on homelessness, rough sleeping in the private sector. Representations to that committee may well result in another critical report which says central government is not funding this adequately. But I think we are all realistic as to what practical impact reports like that actually have. I mean, it is a perennial problem, lack of funding. So lobbying is the obvious answer, but how effective it will be, I'm a bit skeptical. As to legal remedies, I mean, it's something I'd like to give some thought to. It just seems disingenuous for central government to be issuing edicts to local authorities saying you must do this while not providing adequate funding. And they have, obviously, we know, provided some funding and everyone in and subsequently under protect, but it's just not enough. So yeah, something that needs some more thought.
Thank you. And so another one, whilst we've got you, Connor, is are there any other cases that we should be looking out for? Any upcoming litigation that we can keep an eye for?
Just one for my part, which I think many of you may already be aware of. I mean, by way of background to this, it was Conservative Party manifesto commitment that they are going to end rough sleeping. And in typical Home Office fashion, one of the ways they have elected to do this is by introducing a new immigration rule, which means that it will be a breach of the immigration rules to be sleeping rough, which perhaps isn't the sort of humane response that we were hoping for. So Public Interest Law Centre, acting for RAMFEL, the Refugee and Migrant Forum of Essex and London, are crowdfunding to bring a challenge against that rule. So that's obviously at very early pre-action, perhaps even pre-action stages, but that's something I'm going to be watching with interest, because I suspect that is directed at the fact that a large proportion of our rough sleepers, certainly in London, are EU nationals, and they are many of certainly newly arriving EU nationals after 31st are going to be subject to the immigration rules and may fall foul of that.
Thank you. Tamor, Miranda, Raza, are there any other cases that we should keep an eye out for?
Well, no, I think I mentioned the MK case, and there's also the Penally challenge that's coming up, and that's kind of, as I say, incorporating framing the challenge in respect to the conditions in which people are meant to live in perhaps the most egregious setting possible. In other words, asylum, those who have fled conflict are now expected to live in a simulated conflict within a former barracks that has all the hallmarks, as one might expect, of a conflict zone. So, as I say, that case will be making a lot of other arguments as well, but all the issues that are live in the other support cases are live there as well. Tamor, I think he is involved in something.
And so, well, it's actually something we were discussing this afternoon, that there's a problem in this jurisdiction that the nature of the interim relief sort, if successful, often means that you don't get to a substantive hearing. Unless you're bringing a systems challenge and you've gathered your evidence and you have a good argument for getting a declaration from the High Court. And so lots of individual wins that actually establish quite important things. You might get an interim relief judgment. I know Mr. Justice Fordham is very good at getting those out very quickly to assist people in other cases. But there is a slight problem where you get significant Home Office concessions that you think could benefit other people. And it's not always easy to have that in established authority. And of course, we all talk to each other, and the sector talks to each other, and the solicitors talk. But that's worth bearing in mind. And the Home Office are being very good, as always, at seeking to settle and give things to the cases with strong facts in order to make them go away. And of course, we have a duty to our clients to not to continue marching into the High Court when we can get things for our clients. I wanted to say one more thing about Suluk's question about putting pressure on the government, political pressure, I suppose. I've had cases all this year where the failure and dysfunction of the Home Office has led to the local authority having to accommodate someone. Now, Connor's gone, asked the question, okay, under what power was that being done? But during COVID, that was happening. So, on the theme of in defense of local authorities, that dysfunction and failure was leading to the local authority picking up and clearing up the mess, which has an impact on them in terms of costs. And so I wonder if there will be the position of local authorities, a frustration with the current mess in the asylum support system and its impact. But perhaps that's to hope for too much.
Thank you very much, Taimur. So two final, or there's rather three, there's a last minute entry, three final questions, and then we'll bring it to a close. And the first question is, what do you think the future of the NRPF as a policy is? Is there a chance that it will be replaced or repealed, especially as the success rates for challenges has been quite successful, and at least about 90% of applications being overturned? Why continue on a path that potentially passes the buck to local authorities?
And of course, the moment of the year was Boris Johnson not understanding what his own policy, what the government's policy was on this, and he seemed very, very shocked that such a condition could be attached to people who in the UK. I think it might be one of those policies where it's a death by 1,000 cuts, but it does depend on political climate. And if we have 10 more years of Conservative government, which Home Secretary, which Prime Minister is going to run the risk of explicitly changing the policy rather than just loosening it sufficiently such that they don't get hit in the High Court every 6 months?
I mean,
am I a cynic?
If I could just add to that, I mean, I think many of you will be aware of the A Child case earlier in the year, which was a challenge to the NRPF policy. And I think that case really illustrated the difficulties in challenging the policy, because it was brought on 6 grounds, but the court only considered one, which allowed, I mean, the challenge was trying to mount a wholesale attack on NRPF, but the court allowed it on one very narrow ground, which said that the policy wasn't broad enough and it didn't anticipate imminent destitution. And so this systemic challenge didn't get considered because the claim was allowed on a very narrow ground. Now, I'm quite sure that the solicitors and those who were involved in that case will keep trying to challenge that. But I agree with Taimur, in the political climate, unless a challenge like that succeeds, we're not going to see much change. But I do agree with the premise of the question, which is that this is just buck passing by central government to local government, and it's far more principled for central government to be allowing people to access benefits rather than expecting local authority social services departments to do it.
Thank you. So Conor, the last two questions I think are for you. And so in view of the new immigration rules and lack of funding for accommodation, is there now a risk that Part 7 applicants with recourse to public funds will end up NRPF / deported? Which provisions would best protect?
Ubah, you've frozen, but I'm going to try and field the question. I think I can see
which
it.
provisions would best protect a rough sleeping client in the instance that a local authority reported them to the Home Office so that they may minimise their duties?
Yeah, I mean, that's a difficult one. So, I mean, assuming we're talking about people who are in the country without leave to remain, if they apply to a local authority, under whatever power they ask the local authority to exercise, the local authority does actually have a duty under Schedule 3 to report them to the Home Office. And fortunately, that doesn't happen that often. So there isn't really a way of avoiding that. I mean, in practical terms, it's not only do the reports not take place, but the Home Office is not the most efficient of departments. It rarely does anything, as far as I can see, if it gets the reports. But I don't think there is a way to fully insulate people from that. I think people do have to be just warned of the risk. If they are going to be seeking local authority accommodation, they do have to be told there is a risk that your case may be brought to the attention of the Home Office. And really what they need to be doing, what they need to be helped with, is to try to sort out their immigration status rather than glossing over it or hoping that it won't come to the attention of the Home Office.
Okay, well, I mean, in Ubah's absence, I don't know if she's going to come back in. I think we have to draw this to a close. But before we do so, I just wanted to take the liberty, if I may, just reflecting on all the kind of challenges that everyone has talked about today and all the challenges that everyone who's participating in the seminar is thinking about to try and resolve and improve the plight of people who are, the dispossessed and those who are made to live on the brink of destitution. That it brought to mind the late Steve Knafler, who we know birthed or crusaded in many of these cases. And some of us were lucky to share chambers with him or work with him or know him. I certainly had all of those privileges, and that led to important outcomes for those facing destitution. All the people that we're concerned with today, I think I can safely say. And he was an incredible lawyer and a lovely man, more than anything else. He was a very generous man when it came to providing opportunities. And when you worked with him, and it was always generous with his time when it came to advice, no matter how big or small. So I just wanted to acknowledge Steve and his work today, and clearly because his work lives on. And so on that note, I don't know, unless anyone wants to add anything, I was just going to say thank you everyone for joining, especially at the end of very, very hard working days. And I'd like to thank everyone for their engagement. And as I say, you've got everyone's profile details on the mail outs and so on. So if there's anything that arises from this seminar that anyone would like to ask questions about later on, please feel free to do so. But otherwise, thank you so much for coming, and hopefully we'll see you next time.
Thank you very much, everybody.